皆様お待たせいたしました。それでは午後の部を始めさせていただきます。まずオーストラリアのプレゼンテーションから始めてまいります。アレンズ法律事務所サラ・マシソン弁護士、同じくアレンズ法律事務所フィリップ・カー弁護士にご説明をいただきます。よろしくお願いいたします。
Good afternoon, ladies and gentlemen. We are going to split the presentation on the Australian legal system between both of us. So I will do the first section and my colleague Sarah Matheson will do the second section. Australia is a federal system, both politically and legally. That means that there is a federal government and there are a number of state governments. The federal government introduces and passes federal legislation, and the Patents Act in Australia is a piece of federal legislation. So far as trials and patent cases in Australia are concerned, they are predominantly heard in the federal court, almost universally. That is the case despite the fact that under the Patents Act, state courts do in fact have jurisdiction to hear patent cases, but it's very unusual for litigants to commence proceedings for patent infringement in the state Supreme Courts. It's not unheard of, but it's very unusual. The cases in Australia are heard by a single judge, that is the trials, and there is no jury system in Australia, unlike in the United States. And the cases are split into phases. Predominantly, the first phase comprises the hearing on liability, and in Australian cases, liability will comprise both the infringement case and validity. Unlike the system that we heard this morning in Japan and Korea, validity is determined within the federal court system and heard by the judge. In this mock trial, of course, validity is not an issue, and the only issue before us is infringement. Separately, the hearing on damages will be heard normally after liability has been determined, and the successful party has the right to choose between damages or an account of profits. And before determination of that issue, the successful patentee is entitled to obtain discovery of documents from the infringer so that they can make an informed decision about whether they choose damages, which is the loss the patentee has suffered, or an account of profits, which is the profit which the infringer has made. There is a right of appeal, of right from the trial judge to what is called the full court of the Federal Court of Australia. The full court will normally comprise 3 judges, but in matters of major significance, the court can sit a panel of 5 judges. Recently in Australia, 5 judges determined a case about a computer-implemented business method patent because it was considered important for the court system to have a full bench of 5. There is a right of appeal, but only with leave, to the ultimate appellate court in Australia, which in Australia is called the High Court of Australia. We have a system in Australia not unlike that in the United States, which in the United States is called certiorari. You have to make an application to the High Court for leave to appeal. Today, most applications for leave to appeal are determined on the papers. Originally, the parties had a right of oral address to the court, and they were entitled to 20 minutes each. But now most leave applications are determined on the papers with no right of oral address. I'm now going to look at the typical flow of a patent case. I'm not going to go into this in enormous detail. I think you all have the slides in front of you. In Australia, patent cases are, I think I've gone too far. Yes, sorry. Patent cases are started by way of an application in the federal court, normally after the patentee has given notice by way of a letter of demand to the infringer, calling upon the infringer to cease the infringement. In circumstances where the alleged infringer doesn't cease, the patentee is then entitled to commence proceedings. That is done by way of an application and statement of claim with particulars of infringement, which will set out the basis by which the patentee alleges that various claims of the patent have been infringed by the alleged infringer. The matter is then brought before a single judge for a case management and directions hearing, in which the single judge will fix a timetable for the way in which the case will be conducted, by way of the filing of pleadings and by way of timetable for the evidence which will be filed. In most patent cases, although not in the mock trial, as I said, validity will be in issue, so the alleged infringer will raise issues such as lack of novelty, lack of inventive step, and issues relating to what we would call patent specification matters, clarity of claims, lack of enablement, lack of sufficiency, etc. The important issue in Australian patent litigation is that the judge will not normally have any technical assistant sitting with him or with her, and the parties will lead their own expert evidence, which will set out matters which they feel need to be addressed by the way of experts. And they will file affidavit reports setting out the nature of the expert evidence which they will give. The judges now will normally direct that the experts meet prior to the trial to try to reduce the matters in dispute between them, and in many cases the judges will order that the experts actually give evidence jointly at the ultimate trial. We quaintly call that in Australia the hot tub, where the experts will sit in the witness box together. The judge can ask the experts questions, the experts can ask each other questions, but counsel can also cross-examine the experts. Often the judge will restrict the areas on which cross-examination is allowed, particularly where the experts have themselves reduced the matters about which they are in dispute. After the trial has been concluded, there will be addresses, obviously, from counsel on the matters which have been raised during the trial. The judge will then adjourn the court for delivery of judgment, which can take some time. It's not delivered immediately at the conclusion of the trial. After the judgment is delivered, there will often be a debate about the remedies which are to be allowed. In Australia, as a matter of usual course, a final injunction will be issued to restrain the defendant from infringing if the patentee has been successful, and then an order will be made for there to be an inquiry in relation to the damages or an account of profits. The usual question of that hearing will be dealt with separately and after the liability, and very often separately and after any appeals. So in many cases, the injunction will be stayed pending the determination of the appeal, and the inquiry of damages or an account of profits will not actually occur until after all appeals have been dealt with.
I'm just going to briefly describe a couple of particular aspects of patent litigation in Australia, and the first is costs of patent litigation. So as a general rule, Australia is what we refer to as a cost consequences jurisdiction. This means that the losing party is generally ordered to pay the costs of the winning party. Costs are always at the discretion of the court, but a successful litigant in patent litigation in Australia could generally expect that the court would make an order in their favour, and they will generally recover around 40 to 60% of the costs they've actually incurred in running the case. They won't recover all of their costs, but they'll get some of their costs back, and the losing party will have to pay those costs, and of course they'll have to bear their own as well. The other point I wanted to briefly mention, because it relates to costs, is the position of foreign litigants. So in Australia, many patents are granted to foreign corporations, and we have particular rules in Australia which have been developed by our federal court and are set out in our patent statute, which only gives standing to sue for patent infringement to the patentee and or their exclusive licensee. And we define exclusive licensee extremely strictly, such that unless the licensee is given all of the rights that the patentee has, they're not considered exclusive. So this means that it is often the case that it is the foreign patentee who is the party in the proceeding. And where the plaintiff in Australia is an overseas company without any realisable assets in the country, it is quite common for the defendant to apply for an order that the plaintiff gives security in the event the plaintiff is ultimately unsuccessful and there are costs orders made against the plaintiff. And that is normally given by way of a bond or a guarantee, and if that money is not provided as security for costs that may ultimately be ordered, then the proceeding could be stayed or indeed dismissed altogether. Just turning to the definition of patent infringement in Australia, our Act doesn't specifically define infringement. However, it's understood to mean that exploitation of a product, a process or a method. And I won't read from the slide, but you'll see here that there is a definition there where the invention is a product or where the invention is a process. And to determine infringement, the court first has to construe the claims. And for a finding of infringement, the alleged infringer must have taken all of the essential features, which we refer to as the essential integers of the claim. So this brings me to some general principles of claim construction in Australia. It's well established that construction of the claims is a matter of law. And this means that it's for the court to determine how to construe the claims. There are some well-established principles which are frequently restated in federal court cases. And from this we know that the court must first construe the claim from the perspective of the person skilled in the art. And the question here for the judge is, how would the person skilled in the art have understood the patentee to be using the words in the claim in the context of the specification as a whole? Now, while the claim needs to be construed in the context of the specification as a whole, if a claim is clear and unambiguous, its meaning should not be narrowed or expanded based on other parts of the specification. A claim must also be construed in light of the common general knowledge, including the art before the priority date. It's often said that common sense needs to be applied in construing claims. And what this really means is that if the claim contains ordinary words, the idea is that they should just be given their ordinary meaning. So unless the person skilled in the art would give words in a claim a very particular meaning, or unless the patent specification itself ascribes a particular meaning to a term, then their ordinary meaning should be the preferred construction. We heard this morning about literal infringement. Very importantly, for the purposes of claim construction in Australia, we adopt a purposive construction. This means that words have to be read in their proper context, and they must avoid a construction that is too technical or too narrow. And it also means that the individual features of a claim should not be considered in isolation. However, a purposive construction does not mean that it's possible to go beyond the technical matter in the specification, such that the patentee can claim a monopoly over the mere ideas disclosed in the specification. Philip referred to the use of expert evidence in Australian patent cases, and it's quite usual in an Australian patent case for the parties to present expert evidence on claim construction. However, it's ultimately for the court to determine whether to accept that evidence. And this will be dictated by the nature and complexity of the case and the patent and the underlying technology. But it's for the court to decide whether or not they need to hear from an expert, because it's ultimately for the court to construe the claims. Finally, I just wanted to touch on the use of the Patent Office file. We heard some arguments this morning about file wrapper estoppel, and Australia, unlike a number of jurisdictions, including some of those we've heard from this morning, is different in that it will not usually be permissible to rely on the Patent Office file in the aid of claim construction. So unlike, for example, the United States, an admission made by the patentee during prosecution will not amount to an estoppel, and the opponent in litigation will generally not be able to rely on any representations previously made to the Patent Office. This concludes our presentation on patent process in Australia, and we'll now begin the mock trial.
ありがとうございます。それでは引き続き模擬裁判を行っていただきます。模擬裁判の配役をご紹介いたします。すでにステージ上にいらっしゃるお二方、原告代理人役はアレンズ法律事務所のサラ・マシソン弁護士、そして被告代理人役はアレンズ法律事務所のフィリップ・カー弁護士です。そして裁判長役はオーストラリア連邦裁判所ジョン・ニコラス裁判官です。ご起立願います。
In the mock trial, we pick up from the point in the trial at which all of the evidence has been given, the witnesses have been cross-examined, and there have been rulings on evidence. One of the rulings on evidence that would have been made by this point was in relation to the written opinion. And for reasons I will explain in the judgment, the opinion was rejected and not admitted into evidence, essentially for reasons that Ms Matheson has referred to. So we're now at the point of the trial where we hear submissions from the parties' attorneys. And we'll begin with the plaintiff. Ms Matheson.
Your Honour, I will now briefly summarise the key features of the invention. The invention is a method of using a system for a particular purpose. That purpose is car navigation. There are a number of physical elements required for the system. These are a first memory means, a second memory means, and a display screen. The function of the first memory means is to store facility data for a plurality of service facilities. The facility data comprises display data and coordinate data. The display screen is then used to select a service facility from the available options based on the display data read out from the first memory means. The coordinate data for the selected service facility is retrieved from the first memory means and stored as user-registered data in the second memory means. Finally, the coordinate data is retrieved from the second memory means and displayed as a position on a display screen superimposed on a map of the relevant area. I'll now turn to the respondent's method. The claimed invention is a method, and the plaintiff contends that the defendant's use of the D method is use of the claimed method, or alternatively, that the D service is a product resulting from use of the claimed method. The D method is a method of using a system for the same purpose as that of the applicant's invention, which is car navigation. The function of the server is to store D-spot data, being data and position data for a plurality of spots. The terminal includes a display screen, which is used to select a location from the available options based on the name data read out from the server. The position data for the selected location is retrieved from the server and stored separately as memo data. Finally, the position data retrieved from the server is displayed as a position on the display screen of the terminal, superimposed on a map of the relevant area. As Your Honour can see from the features of the D method, it is the plaintiff's submission that the features of that method correspond precisely to the essential integers of Claim 1 of the plaintiff's patent, and the D method therefore infringes that claim. Your Honour, this is a very simple case. It requires a very straightforward application of very well settled principles of claim construction. For convenience here on this slide, we've broken up Claim 1 into its various integers, then grouped them for the purpose of construing the disputed terms in the claim. The first question is whether the system used by the defendant is a car navigation system. It's without doubt that the D method is a control method for a car navigation system that displays a map on a display screen. The respondent effectively describes its method as that. Your Honour has heard from both experts, and as is clear from that evidence, the term car navigation system does not have any technical or any special meaning. They're ordinary words, they should be given their ordinary meaning. As Your Honour is well aware, it's a well-established principle under Australian law that where the terms of the claim are clear, it's not necessary to import anything from the specification in order to construe them. And there is nothing in Claim 1 that requires the method to be used with the car navigation system have all physical components installed in the vehicle. To the extent that the defendant says otherwise, Figure 1 in the specification describes an embodiment of a preferred car navigation system according to the invention. It's merely an example, and Figure 1 cannot be used to narrow the scope of Claim 1. As Your Honour has heard from the plaintiff's expert, the reference to a car navigation system would be understood by the skilled person as broadly any system used for the purpose of navigating a vehicle from one location to another. As such, the first integer of the claimed method is present in the D method. Your Honour, I'll now turn to the first memory means, being the group of integers set out in the second column of the slide. The first memory means is defined in Claim 1 by reference to its function. It stores two types of data: facility data, comprising display data, this being the names of locations that can be searched by users. It also stores coordinate data, being geographic coordinates of the locations. The data are read from the memory means. The experts have conferred, and they agree, that a memory means is an electronic storage medium capable of recording information in digital form from which information can be retrieved. The reference to a memory means is therefore well understood by persons skilled in the art. There is no need to refer to the body of the specification for clarification. If, however, one does do that, the specification provides a CD-ROM as an example only of a first memory means. The evidence establishes that many types of storage media were well known by persons skilled in the art at the relevant date. Selecting an appropriate storage medium or memory means is a very straightforward task and doesn't require any specific explanation in the patent. Importantly, the D server performs all the functions of the first memory means. It stores the names and descriptions of locations. It also stores their geographic position. As such, the D method takes all the features of the claimed method relating to the first memory means. In relation to the second memory means, that's again defined by reference to its function. Again, the experts have agreed that the memory means is a rewritable storage medium in which new digital information can be recorded. The only respect in which the experts' opinion differed is in relation to the question of whether the second memory means must be a separate storage location from the first memory means. Your Honour, this difference is easily addressed. The authorities establish that the question is whether strict compliance with a term, such as here, the second memory means, should be construed in a way that excludes any variant. You've heard the plaintiff's expert. A second memory means would clearly be understood by persons skilled in the art to refer to a storage location used second in time in the process, and not, or not only, to an entirely separate or second physical component. So the D server, having the capacity to store information and the capacity to temporarily record new information, is clearly a second memory means. Therefore, the claimed features of the second memory means, which appear here on the slide, are also present in the D method. So to conclude, all of the essential integers of the claimed method are taken by the D method, and the D method clearly infringes Claim 1 of the patent. That concludes my submissions, Your Honour.
May I ask one question, Ms Matheson? As I understand your argument in relation to the second memory means, you don't contend that the claim does not require that there be both a first and second memory means. Rather, you say that the D system does incorporate both the first and second memory means.
That's correct, Your Honour.
Yes, I understand. It would be difficult, would it not, to ignore the reference to the second memory means, the word second, suggesting that there's a second something, whether it be a means, a device, or something else.
That's correct. The plaintiff contends that the D method fulfils both the first and the second memory means.
Yes, thank you very much.
If Your Honour pleases.
Yes, Mr Kerr.
If Your Honour pleases, the defendant takes the view that where a claim is clear and unambiguous, it's not appropriate to vary its meaning or to give it an obscure meaning by statements found in other parts of the specification. However, the defendant's submission is that the nature of the car navigation system referred to in the claim is not clear and unambiguous. The expert evidence which has been given, and I'm afraid we haven't got that here, but you could assume that there was expert evidence, were that there are many car navigation systems available, and this therefore created an ambiguity as to what type of car navigation system was being referred to by the patentee. It's therefore necessary to read the specification as a whole and to refer to the body of the specification to determine the scope of the invention. The defendant says that the navigation system described in the body of the specification, including the embodiment and the figures, is limited to a system where all components are installed in the vehicle as a single apparatus. That is, that everything as part of the system must be refer to a single in-vehicle unit, which system is not the case with the D system, where the server is separate from the vehicle. It is the defendant's submission, Your Honour, that the patentee has reverted to adopting a purposive construction when trying to define the first and second memory means. But that shouldn't be allowed to extend the scope of the monopoly which the patentee has. And I think the question which Your Honour directed to the Plaintiff's Counsel was opposite in that regard. That is, the patentee deliberately chose the use of the words first and second. If the patentee had not intended to refer to two separate things, the patentee would not have used those words in the body of the claim.
Mr. Kerr, can I just ask you this? Ms. Matheson says that first and second may be being used in the claim in a temporal sense rather than a physical sense. So they're referring not to different means, but possibly the same means operating at two different points in time.
I would have thought then, Your Honour, that the way in which the claim would have used those words would be firstly and secondly in terms of describing something which is temporal. Here what has been used are the words first and second, and the defendant submits that they are describing two separate physical things. So that in the D method, where they're not two separate physical things, those elements of the claim are not satisfied. What the patentee has done is to focus on the functionality of the claim system and method, and what would appear to be being done, Your Honour, by the patentee is to introduce, by way of the back door, some sort of doctrine of equivalence into Australian law. Now, while the doctrine of equivalence has been accepted in a number of jurisdictions, the United States, Germany and France, and most recently in the United Kingdom, that the doctrine of equivalence does not form part of Australian law and therefore should not be used by the patentee as a way of attempting to cover what the D server is doing. The doctrine is not part of Australian law, and therefore what is required is to look at those elements of the claim and whether they are satisfied, and examine the D server system to see whether or not that satisfies the claims. And it is the defendant's submission, Your Honour, that the deliberate choice by the patentee of the words first and second describes something which is in fact separate, and for that reason is not satisfied by the defendant's system. Those are the submissions on behalf of the defendant.
Yes, thank you, Mr. Kerr. Ms. Matheson, anything in reply?
Your Honour, I'll keep my reply brief. I would just like to pick up on one point made by my learned friend, and that is whether or not the plaintiff is trying to introduce the doctrine of equivalence into Australia. Your Honour, the plaintiff has no need to try to do that and no need to rely on the doctrine of equivalence. Rather, there is complete correspondence between the essential features of the claimed method and the D method. In the D method, the D server is the first memory means, and the D spot data corresponds to the claimed display data, being the name or description of a location. The D position data corresponds to the claimed coordinate data, being the latitude and longitude of the selected spot. In both methods, the user then selects one of the particular stored locations from the display screen, the coordinates of which are retrieved from the storage or memory means and then temporarily recorded thus becoming the user-registered data or memo data. In the D method, the D memo data corresponds to the claimed user-registered data, this being the data that the user has instructed the system to remember for the time being. The D server is therefore also acting as the second memory means, as previously explained in answer to Your Honour's question. I have nothing further, Your Honour.
Yes, thank you, Ms Matheson. Ordinarily, the court would reserve to consider its judgment, and there is a written judgment that has or will be made available to participants in the symposium. But I will briefly explain why I've come to the conclusion that the plaintiff's infringement case fails and its application for relief should be dismissed. There are some slides which pick up the key points. It's usual in a case such as this for the judge to refer to the relevant principles of construction, which are obviously fundamental relevance to the question of infringement. The relevant principles of construction in Australia, and I think they apply clearly in a number of respects in this case, are these: a patent specification should be read in the light of the common general knowledge in the art as it stood at the priority date. It should be given a purposive rather than a purely literal or abstract construction. It should also be read in a practical and common sense way. The words used in a patent specification are to be given the meaning which a person skilled in the art would give them, having regard to their common general knowledge and what is disclosed in the specification when read as a whole. The claims define the scope of the patentee's monopoly. While they are to be construed in light of the patent specification as a whole, it's not legitimate to narrow or expand the boundaries of the monopoly as fixed by the words of the claim by adding to or subtracting from the meaning of those words based on glosses drawn from the specification. In particular, it's not permissible to read down clear and unambiguous language of a claim by reference to the description of a preferred or exemplary embodiment described in the body of the specification. However, it is permissible to resolve ambiguity in claims by reference to the body of the specification in which they appear. The proper construction of a patent is a matter of law. While experts can give evidence as to the common general knowledge and the meaning of technical or scientific terms, the meaning of the claim is ultimately a matter for the court to determine. Provided a claim is fairly based upon matter disclosed in the specification, and that really touches on a validity question, and there's no challenge to the validity in this case, a claim may define the invention more broadly than the embodiment that is described in the body of the specification. Equally, the claim may define the invention more narrowly than the embodiment that is described in the specification. A limitation in a claim cannot be ignored simply because the embodiment described in the specification is more broadly described or because a valid claim could have been drawn without the same limitation. Further, the fact that a particular integer is a necessary feature of the best method of performing the invention does not require that it be imported into the claim. The submissions that have been made by the parties indicate that there are three matters in issue. The first is whether Claim 1 requires that all of the features of the method for controlling the car navigation system, referred to in Claim 1, be installed in the vehicle. The words car navigation system are clear and unambiguous and not limited to systems having any particular design or configuration. There's nothing in the specification that requires all of the features of the particular method for controlling the car navigation system to be installed in the vehicle. In particular, Claim 1 does not require that either the first memory mains or the second memory mains be located inside the vehicle. The second issue that arises for determination is whether the first memory mains referred to in Claim 1 must be a portable storage medium that can be installed in the vehicle. There's nothing in Claim 1 which requires that the first memory mains be a portable storage medium that can be installed in the vehicle. The relevant language, memory mains, is deliberately broad and should be given full effect. It encompasses any memory means capable of performing the function attributed to it in the claim, regardless of whether or not such means takes a form of a portable storage medium. The fact that an embodiment described in the specification utilises a portable storage device, in this case a CD-ROM, does not provide a sufficient basis for importing any such requirement into Claim 1. The last issue, and the more difficult issue, concerns the question of whether Claim 1 requires that there be a separate second memory means for storing and reading coordinate data as registered user data. The language of Claim 1 refers to first memory means and second memory means, rather than, for example, memory means or one or more memory means, which suggests that the facility data and coordinate data are stored in two separate memory means. However, the language may also, I accept, be understood as extending to a first and second memory means that may be provided by a single memory device serving two distinct memory functions. Claim 1 is ambiguous in that it is not clear from the language used whether the first memory means and the second memory means are necessarily separate components of the car navigation system. Since the claim is in this respect ambiguous, it's permissible to have regard to the description in the specification and the views of the expert evidence for the purpose of seeking to resolve the ambiguity. Having considered the expert evidence and having considered the specification as a whole, in my opinion, Claim 1 should be understood as requiring that there be two separate memory means in the form of two separate devices. This interpretation of Claim 1 finds support in the language of the claim, which refers, as I've said, to a first and second memory means, and in the description of the invention, which also distinguishes between the first memory means, the CD-ROM, and the second memory means, the rewritable RAM. Each of these is a separate component with its own distinct memory function to perform in the method of the invention. They are the reasons for concluding that the application should be dismissed. In relation to my rejection during the course of the trial of the tender of the written opinion, my reasons are as follows. Donkey sought to tender in evidence a written opinion filed by Pony during the course of the prosecution of the application for the patent, in which Pony explained why it disagreed with the examiner's interpretation of certain prior art. It was submitted by Donkey that the written opinion was relevant to the proper construction of the patent. The written opinion was excluded from evidence on the ground that it is not relevant to the proper construction of the patent and is therefore inadmissible. This is because the patent is to be construed in accordance with the principles of construction previously discussed, which do not usually permit the court to receive opinion evidence as to the meaning and effect of the claims or the prior art, except by way of admissible evidence from an expert witness qualified as a person skilled in the relevant art. The conclusion is that Claim 1 requires that the method for controlling the car navigation system utilise a first memory means and a second memory means constituted by two separate memory devices. The D system utilises a single memory device that performs the functions of both the first memory means and the second memory means. It follows that the D system does not infringe Claim 1. For those reasons, the plaintiff's application will be dismissed with costs. That completes the mock trial for Australia. Thank you.
オーストラリアの皆様方ありがとうございました。 以上でオーストラリアの模擬裁判を終了とさせていただきます。